Veuillez vous asseoir. L'audience est ouverte. La Cour se réunit aujourd'hui pour entendre le premier tour de plaidoirie de la Somalie. Je donne à présent la parole à son Excellence Monsieur Mona Al-Sharmani, agent adjoint. Madame, pardon. À son Excellence Madame Mona Al-Sharmani, agent adjoint. Excellence, vous avez la parole.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the Court, it is a great honor and a privilege for me to appear before you today as Deputy Agent for the Federal Republic of Somalia. With me on behalf of the Somali government is our co-agent, His Excellency Ali Saeed Faqi, Somalia's Ambassador to the Kingdom of Belgium, and the Honorable Ahmed Dahir, Attorney General of Federal Republic of Somalia. Please allow me to begin with an expression of thanks. The President of Somalia, His Excellency Hassan Sheikh Mahmoud, has personally asked me to convey to you, to the entire Court, the gratitude of the Somali nation. This is the first time Somalia has appeared as a party before an international court or tribunal. Even at this early stage, we have been greatly comforted by the efficiency and impartiality with which you have managed our case. We are confident that this court will, as its name attests, do justice in accordance with international law. We also wish to thank the Honorable Agent of Kenya for the kind greetings he extended to us yesterday and returned to him and his team warmly. Mr. President, distinguished members of the Court, it is no secret that Somalia has faced considerable challenges. Our recent history has been fraught with instability, poverty, and conflict. For long years, we have endured civil war, humanitarian disasters, and the scourge of terrorism. But a brighter future is within our grasp. Since 2012, Somalia has had a functioning federal government under the leadership of President Hassan Sheikh Mahmoud. With the support of international partners, we have a constitution that enshrines the rule of law and parliamentary democracy as bedrock principles. Public institutions are being rebuilt. Next month, we will have presidential and parliamentary elections. And life is springing back to cities like Mogadishu, Hargeisa, Bosaso, Kismayo, Galkayo, Baydawa, and many other places in Somalia. Local businesses are doing well. A new generation of Somalis is graduating with educational training, and many in the Somali diaspora are returning to assist the rebuilding efforts. We recognize and express our deep gratitude to our Kenyan brothers and sisters for their enormous assistance in making this possible. In fact, we wish to thank all our African and other partners who continue to stand shoulder to shoulder with us in taking our country forward. Mr. President, members of the Court, for the first time, Somalia is in a position to have recourse to international dispute settlement mechanisms to protect our rights under international law, including our rights over marine areas and the resources they hold. As one of the world's poorest countries, those resources are critical natural assets vital to the future prosperity and stability of our nation. They will play a key role in assuring Somalia's continued development in a way that benefits our people. Yet, our ability to explore for, let alone exploit, those natural resources has been seriously hindered by the lack of a defined maritime boundary with Kenya. In the absence of an established boundary, Somalia has exercised restraint and refrained from activities in the disputed area. Regrettably, Kenya has not taken the same approach. It seems to consider that the area in dispute belongs to it. Yesterday, you heard the Honorable Agent for Kenya claim that Kenya has exercised uncontested jurisdiction in this maritime area since 1979. Somalia does not agree. But the statement does reflect Kenya's misguided attitude. Kenya has moreover granted concessions in the area, and exploration activities are already taking place. Kenya's approach is of great concern to Somalia. The resolution of this case in a matter that achieves an equitable solution in accordance with the rule of law will allow us and others to know what is rightfully ours and realize our full potential. It is for that reason that the issues that are at the heart of this case unite all Somalis. Whatever other differences may divide us, it is no exaggeration to say that the eyes of the entire Somali nation are upon us today, and they will remain upon us until this court renders its ultimate decision. Mr. President, distinguished members of the court, I know the issue that brings us today concerns Kenya's objection to the court's jurisdiction, not the merits of the case. But speaking on behalf of the government of Somalia, we think it is important for you to understand something of our motivation for coming before you, and how the Somali nation has entrusted its aspirations to you. Yesterday, you heard Ambassador Muchiri suggest that Somalia rushed to the court without giving negotiations a chance to succeed. The Honorable Ambassador hinted that the institution of these proceedings was an act of bad faith. She even accused us of deception. With great respect to our neighbors, Somalia takes great exception to that unfortunate and erroneous characterization. Appeal to international justice should never be considered an act of bad faith. On the contrary, the institution of proceedings in this great court is an act of faith. Faith in Somalia's capacity to defend its sovereignty and sovereign rights, faith in international justice, and faith in this court's wisdom. That is why we are here today. We seek nothing more and nothing less than to have our maritime boundary dispute with our Kenyan brothers and sisters be resolved finally and definitively in an equitable manner, in accordance with the requirements of international law, including the law of the Sea Convention. Doing so will serve the interests of peace and stability in the region, and it will confirm the central role of this court in resolving disputes of this kind. Somalia has not rushed to the court prematurely. As the evidence Somalia has placed before you demonstrates, we negotiated in good faith and with great effort and energy before initiating those proceedings, but to no avail. I personally had the honor of participating in those negotiations over 2 intense rounds. They were not just technical level meetings, as you heard yesterday. Indeed, our respected foreign ministers personally presided at the second round. The talks were hard and sometimes heated. The position taken by the parties were far apart and irreconcilable. Kenya insisted that the boundary must follow a parallel latitude. Somalia insisted that the jurisprudence of the court and other international tribunals required a delimitation based on equidistance. We could not even agree on a method of delimitation, let alone a boundary. Views were exchanged, no movement occurred. Kenya then failed to honor its commitment to attend a subsequent meeting, a meeting that it insisted on having as a last and final resort, and did so without prior notice or later explanation. We only learned of its purported security concerns when it filed its preliminary objections in October 2015. Counsel for Kenya asked yesterday why we submitted our application so promptly after Kenya failed to attend those meetings. The answer is very simple. As you will hear, our counsel will explain shortly, this third meeting was specifically intended to be a final opportunity, a last try to bridge our differences. There had been no movement during the prior sessions, and Kenya's unilateral activities in the disputed area were ongoing. Adding to the sense of urgency was the knowledge that Kenya could, by its terms, withdraw its Article 36(2) declaration at any time and forever prevent us from accessing this great court. Under the circumstances, Somalia did what any prudent state would do. We considered our options and prepared for all contingencies. When Kenya failed to turn up for the third and final round of talks without explanation, we felt we had no alternative but to come before this court to protect our rights under international law. Mr. President, members of the court, Kenya's objection to your jurisdiction is, as you heard yesterday, founded primarily on the argument that the 2009 MOU constitutes an agreement to have recourse to some other method of dispute settlement within the meaning of Kenya's reservation to its Article 36(2) declaration. Somalia disagrees. In our view, the one and the only purpose of the MOU was to assure that there would be no obstacle to the CLCS consideration of our two countries' submissions concerning the establishment of the continental shelf beyond 200 nautical miles. The very title of this document confirms this. The MOU is entitled Memorandum of Understanding between the Government of the Republic of Kenya and the Transitional Federal Government of the Somali Republic to grant each other no objection in respect of submissions on the outer limits of the continental shelf beyond 200 nautical miles to the Commission on the Limits of the Continental Shelf. There is no indication that the MOU was intended or indeed, in fact, established an agreed method of dispute settlement that could bar this court's jurisdiction. As our very able counsel will show in the course of this morning, at no time, whether before or after the signing of the MOU, did Somalia or Kenya understand the MOU to have the effect Kenya now seeks to ascribe to it. As I said, we did negotiate and negotiate hard. The record shows that we engaged in a substantive and detailed exchange of views. Kenya never once expressed the view that negotiations were provisional only, and that any agreement, should there be one, would have to wait until after the CLCS has issued its recommendations. That would have been illogical and contrary to Kenya's express wish to reach an amicable solution promptly. Mr. President, members of the court, in Somalia's view, Kenya cannot truly believe that the MOU created a binding commitment to an alternative method of dispute settlement. Rather, it appears that Kenya is looking for a way to avoid the court's exercise of jurisdiction and thus avoid a binding judgment upon the parties. It is hard to avoid the conclusion that Kenya lacks confidence in the merits of its case. The court has never delimited a boundary on the basis of Kenya's approach, and the applicable international law, the 1982 Convention, does not direct it. Nor do the decisions of other international courts or arbitrary tribunals offer support to Kenya's unlikely arguments. Perhaps that's why Kenya has now fallen back to an even more unlikely argument, that UNCLOS itself constitutes an agreement to an alternative method of dispute settlement within the meaning of its reservation to its Article 36(2) declaration. This argument, which took up all of one sentence in Kenya's written pleading, has now assumed a much greater prominence. As Professor Sands will show, it can be rejected just as easily. Kenya is represented by able and experienced counsel. It knows that it does not have a serious case on the merit, but if they can force us back into negotiations without hope of judicial recourse, they can refuse to agree unless we give them a large portion of our EEZ and continental shelf something no self-respecting Somali government could ever do. Kenya can use its greater political and economic power to prevent us from accessing the resources to which international law entitles us. Moreover, continued uncertainty over the course of our maritime boundary does not benefit anyone. The dispute will remain an unwelcome source of tension between our two countries at a time when what is needed is more increased cooperation. If we are to have any hope of a durable and equitable solution that contributes to regional peace and security, it lies here in this great hall of justice and in the hands of the distinguished members of this court. Mr. President, members of the court, with that I come to the organization of our first round presentations. Following me to the podium this morning will be Professor Alain Pillay. He will explain why, as a simple matter of treaty interpretation, the MOU does not constitute an agreement to settle the parties' delimitation dispute by the exclusive means of negotiation only after the CLCS issues its recommendation. Professor Pillay will be followed by Mr. Paul Reichler, who will address the evidence relevant to Kenya's preliminary objection. Mr. Reichler will address circumstances of the MOU's conclusion and show that no one at any time took the view that the MOU created or was intended to create a dispute settlement mechanism. This includes Norway, which was instrumental in the drafting and signing of that document. Mr. Reichler will show that the only purpose of the document was to enable the CLCS to consider both Somalia's and Kenya's submission in respect of the continental shelf beyond 200 nautical miles. Mr. Reichler will also show that the conduct of the parties following the execution of the MOU constitutes further compelling evidence that neither Kenya nor Somalia considered the MOU to have established a specific or exclusive means of settling the maritime boundary dispute, let alone one that obligated the parties to resolve the dispute only by agreement and only after the CLCS had issued recommendations on their respective submissions. Finally, Professor Philippe Sands will demonstrate that the MOU does not fall within the scope of Kenya's reservation to its optional clause declaration. He will also show that even if the MOU had created an obligation to engage in negotiations, which Somalia emphatically rejects, any such obligation has been amply fulfilled. He will also show that Kenya's newly developed argument based on clause is ill-conceived. On any view, then, there is no bar to this court's jurisdiction. Mr. President, members of the court, thank you for your time and courteous attention. I ask that you now invite Professor Pillay to the podium.
Je vous remercie, Madame. La parole est à Monsieur le professeur Alain Pillay.
Merci, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs de la Cour, tout à l'heure, le professeur Sands montrera que le Memorandum of Understanding, le MOU, n'entre pas dans les prévisions de la réserve du Kenya à la compétence de la Cour. Cela suppose de préciser sa signification. Telle est la tâche que Maître Reichler et moi nous partageons en suivant la voie tracée par les articles 31 et 32 de la Convention de Vienne sur le droit des traités. Il m'échait d'établir que l'interprétation du MOU avancée par le Kenya conduit à un résultat manifestement absurde et déraisonnable lorsqu'on en interprète le texte de bonne foi, dans son contexte et à la lumière de son objet et de son but. Ensuite, il maestro montrera que dans la pratique ultérieurement suivie par les parties, aussi bien que dans les travaux préparatoires et les circonstances dans lesquelles le mémorandum a été conclu, confirment entièrement l'interprétation que nous en faisons. Et je vous prie, Monsieur le Président, comme je prie les mannes de bas de vent, de bien vouloir me pardonner, ce mémorandum, je le désignerai par son sigle anglais, MOU, car mémorandum de compréhension ne signifie strictement rien en français, et ni MOU ni MOU ne sonnent particulièrement bien dans la langue de Racine et de Baudelaire. Toute l'argumentation du Kenya contestant votre compétence pour vous prononcer sur la requête de la Somalie repose sur le dernier paragraphe du MOU, ou plus exactement sur un membre de phrase de ce paragraphe qui l'isole de son contexte. I quote, "The delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles," and this is the phrase, "shall be agreed between the two coastal states on the basis of international law after the Commission has concluded its examination of the separate submissions made by each of the two coastal states." End of quote. Kenya contends that this paragraph, and I quote it, sets forth the method of dispute settlement that would follow the CLCS review and specifies that it shall apply to the entire maritime boundary, both within and beyond 200 nautical miles. End of quote. Négligeant la règle générale d'interprétation, cette interprétation originale ne tient compte ni du contexte de la disposition sur laquelle le Kenya fait fond, ni de l'objet et du but du MOU, ce qui conduit à un résultat qui est manifestement absurde et déraisonnable. Monsieur le Président, dans sa présentation d'hier matin, Mathias Forto a résumé en moins de 2 minutes les 5 premiers paragraphes du MOU pour se concentrer exclusivement sur ce paragraphe 6. Quant au professeur Akavan, il a embrayé immédiatement sur celui-ci, sans s'embarrasser le moins du monde des paragraphes précédents. Ce faisant, ils ne tiennent aucun compte de la règle générale d'interprétation énoncée à l'article 31 de la Convention de Vienne de 1969, dont j'ose à peine rappeler qu'il exprime le droit international coutumier. Je précise au passage, Monsieur le Président, que je me fonde sur cette disposition sans pour autant concéder, ni d'ailleurs nier, que le MOU soit un traité en vigueur entre les parties. Il n'est pas nécessaire de prendre position sur ce point, il suffit d'interpréter cet instrument pour constater qu'il ne constitue nullement un obstacle à l'exercice de votre compétence. Et il est reconnu et indiscutable que la règle de l'article 31 de la Convention de Vienne s'applique aussi, par analogie, à des instruments non conventionnels. En vertu du premier paragraphe de cette disposition, un traité doit être interprété de bonne foi suivant le sens ordinaire attribué aux termes du traité dans leur contexte et à la lumière de son objet et de son but. Conformément à l'article 31 de la Convention de Vienne, le sens ordinaire des termes d'un traité ne peut être défini que dans leur contexte et à la lumière de l'objet et du but du traité. Et c'est cela, Monsieur le Président, la règle générale d'interprétation. C'est une norme globale et complexe dont on ne peut détacher les éléments un par un comme on effeuille la marguerite. Une règle tellement bien établie que la Cour n'a pas besoin de s'y attarder longuement, elle l'applique dans sa globalité sans ressentir le besoin de s'en expliquer. Dans son rapport final sur le droit des traités de 1966, la Commission du droit international avait expliqué, je la cite, qu'en mettant le titre de l'article « Règle générale d'interprétation » au singulier, la Commission avait voulu indiquer que l'application des moyens d'interprétation prévus dans l'article constituait une seule opération complexe. tous les différents éléments tels qu'ils s'y trouvent présents dans une situation donnée seraient jetés dans le creuset et la résultante de leur interaction constituerait l'interprétation juridiquement pertinente. Ainsi, l'article 27, qui allait devenir l'article 31, est intitulé « La règle générale d'interprétation au singulier » et non « Regles generales » au pluriel, parce que la Commission a voulu souligner que le processus d'interprétation constitue un tout et que les dispositions de l'article forment une seule règle étroitement intégrée. Fin de citation. Cette caractéristique essentielle de l'article 31 et ses conséquences pratiques ont été excellemment rappelées dans la sentence arbitrale du 12 mars 2004 rendue dans l'affaire de l'apurement des comptes entre la France et les Pays-Bas, qui a insisté vigoureusement sur l'unité de la règle générale d'interprétation posée à l'article 31. Telle est aussi la jurisprudence constante de la Cour, qui a toujours pris grand soin de ne pas détacher les uns des autres les 4 éléments clés énumérés à l'article 31, texte, objet et but, contexte et pratique ultérieure. Comme le disait déjà la Cour permanente en 1922, lorsque l'on procède à l'interprétation d'un traité, je cite, « il faut évidemment lire celui-ci dans son ensemble et l'on ne saurait déterminer sa signification sur la base de quelques phrases détachées de leur milieu et qui, séparées de leur contexte, peuvent être interprétées de plusieurs manières. » C'est dire aussi que l'interprétation, selon la règle coutumière codifiée à l'article 31 de la Convention de Vienne, est en dernière analyse un exercice global qui ne devrait pas être mécaniquement scindé en parties rigides. Fin de citation. Or, c'est très exactement ainsi que procède le Kenya. Au lieu de s'interroger sur le sens de la disposition à interpréter, il le postule pour décréter ensuite qu'il n'y a rien à interpréter. C'est procéder à l'envers. Il faut d'abord interpréter à la lumière de la règle générale de l'article 31, et ce n'est qu'ensuite que l'on peut déterminer si le texte est clair ou non. Lorsque l'on se livre de bonne foi à cette opération, on constate que le MOU est en effet dénué de toute ambiguïté, mais qu'il signifie le contraire de ce que nos amis voudraient lui faire dire. S'il y avait une ambiguïté, il faudrait alors recourir aux moyens complémentaires de l'article 32. Ici, on peut y recourir, mais non pour dissiper une ambiguïté, il n'y en a pas, pour confirmer l'interprétation qui résulte de l'application de la règle générale, globale, complexe de l'article 31. L'interprétation qu'avance le Kenya s'en émancipe totalement. Elle ne tient compte ni de l'objet et du but du MOU, ni de son contexte. Ancelotti, Monsieur le Président, n'avait pas toujours raison. Mais on ne peut que partager, au sujet de l'évidentialisme kényan, la perplexité qu'exprimait le grand juge italien au sujet de l'interprétation de la Convention de 1919 concernant le travail de nuit des femmes, lorsqu'il se demandait, je le cite, « comment il est possible de dire qu'un article d'une convention est clair avant d'avoir déterminé l'objet ou le but de la Convention. Car c'est seulement dans cette Convention et par rapport à cette Convention que l'article assume sa véritable signification. La première question qui se pose est donc celle de savoir quels sont l'objet et le but de la Convention dans laquelle se trouve placé l'article à interpréter. » Fin de citation. Et vous-même, mesdames et messieurs les juges, avez souvent et abondamment insisté sur la nécessité de tenir compte, dans toute interprétation, du but et de l'objet de l'instrument en cause. Comme l'a relevé assez récemment la CDI, je le cite, « je la cite, « Il n'est pas facile de synthétiser en une formule unique l'ensemble des éléments qui doivent être pris en considération pour déterminer dans chaque cas concret l'objet et le but du traité. Cette opération relève sans aucun doute davantage de l'esprit de finesse que de l'esprit de géométrie. Esprit de finesse dont j'ai le regret de constater que nos amis et contradicteurs manquent fâcheusement lorsqu'il s'agit du MOU dont ils s'obstinent à vouloir interpréter géométriquement une phrase isolée de son contexte. Dans cette même étude récente, la CDI a tenté la synthèse suivante. L'objet, je la cite, « L'objet et le but du traité doivent être déterminés de bonne foi en tenant compte de ces termes dans leur contexte, en particulier du titre et du préambule du traité. On peut également avoir recours aux travaux